Right. Good afternoon, everyone, and welcome to this session on online commerce and competition law. For those of you who don't know us, I'm Harish Narasappa, and my partner Arjun Krishnan is joining from our Delhi office. Arjun also heads our competition law practice. Now, online commerce, of course, gives us all sorts of visions as to what it is. Is it equivalent to an online mall, or is it equivalent to an online high street, or is it equivalent to our markets online? And of course, in terms of phraseology, all sorts of phraseology is being used by the market participants themselves as to what they do. What we thought today is we will cover a wide range of issues that are at the intersection of technology, commerce, and competition law. Now, not all of them necessarily, not all the issues that have arisen in the public sphere will get covered today, but we hope to cover a fair bit of ground. And not all the issues are directly relevant to some of the questions you may have in mind, but it will give you a fair bit of overview of where the law stands today and what we can expect as we move more and more from the physical world of commerce to the online world of commerce. So Arjun and I will, speak for about half an hour to 40 minutes, and then we will open the floor for questions. Can I request each of you to type in the questions in the Q&A feature, and we will take the questions after the 35 to 40 minutes that we speak for. So Arjun will lead. So over to Arjun.
Hi, good evening, all of you. Hope you're all safe and well at home. And thank you all for participating. I think we've got over 100 registrations for this topic. So obviously it is something that is of a lot of interest to a lot of people. Starting off, I will just begin by giving a overview of what the Competition Act involves. And then we move on to what it involves for online markets and some of the important and interesting questions that have arisen in recent times. Ria Shivani, could you just go to that first slide? Thank you. So there are two kinds of particular acts or actions that we will be discussing in this presentation. The first is really about anti-competitive agreements. And the second is abuse of dominance. Now there's a third kind of thing which also comes within the regulatory ambit of the body which is set up under the Competition Act, which is called the Competition Commission of India, and that is the regulation of mergers and combinations in the market, M&A. So we will touch upon that in this process also, but our focus today is really on these two kinds of actions: anti-competitive agreements and abuse of dominance. So anti-competitive agreements are really of two varieties. The first is what are called horizontal arrangements. Now these are classified as those agreements or arrangements which are there between market players who are at the same level. So for example, who are in the same level of the supply chain, I should say. So two manufacturers who are in the same market, if they collude to fix the prices of their products, that would be something which is prohibited by the Competition Act. Again, now if those two manufacturers or suppliers say that, look, you operate in X state and I will not operate in that state, and I will exclusively operate in some other state, that is also a kind of prohibition, which is absolutely prohibited almost by the Competition Act. And those are horizontal arrangements are deemed to be not fair and prohibited under the Act. The second type of arrangement is what is called a vertical arrangement, and we see a lot of these in businesses today. For example, a car dealership, right? Where someone has the exclusive dealership to sell cars in a particular city of a particular manufacturer in a particular area. So these are quite common in business, and they are not necessarily prohibited under the act. And these are arrangements which are between people or firms or enterprises who are at different levels of the supply chain. So the manufacturer and his distributor of his products would have this kind of arrangement. But these are not per se bad. It has to be shown that there is some anti-competitive effect of such an arrangement for it to be prohibited and for the Competition Commission to take action. The other kind of prohibited conduct under the Competition Act is abuse of dominance. Now, what exactly is abuse of dominance? And what is dominance per se? Now, dominance really is the ability of a firm, a business, to conduct its affairs completely independent of the market forces and the ability to influence the consumers and its own competitors in its favor. Now, there are several parameters for assessing, what makes a firm dominant. And perhaps the most important and, common sense one is, what is the market share of the firm? So if it enjoys above 50 to 60% market share, one would generally assume that it is a dominant entity. But of course, in India, in our law, under the Competition Act, that's not the only parameter which we use. So the other parameter, for example, could be, what are the resources? What is the size of the enterprise? How much money does it have? Does it have deep pockets? Is it cash rich? So that's another kind of factor, and there are several other factors. What is important to realize about abuse of dominance is that it prohibits certain kinds of practices, but these practices are not prohibited for everybody. So if you are not a dominant entity in a market, uh, you know, uh, you can pretty much do anything, and that's considered to be fair. It's only if you are of a particular size or have certain strength in the market power, then the question: are certain things prohibited for you, which would otherwise not be prohibited? And in the slide we have listed out some of the things which are abusers, are called abusers of dominance. Uh, Having an unfair or a discriminatory price, including a price that is so low that no competitor can actually match your price. Uh, Limiting or restricting the supply of goods. Denial of market access, preventing your competitors to actually somehow enter the market in which you are operating your business. Tying the goods and services which are completely unconnected together and selling them, and leveraging dominance, which is of a lot of importance nowadays. Of when you have entities who are dominant in, say, the physical sphere, are they able to somehow leverage their operations and their dominance when they transition to the online sphere? One of the important sort of questions that has arisen is in respect of the online space is the online space a separate kind of market in which businesses compete, or is it just one of the methods in which or by which businesses can sell their products? Now, it's important to note that the definition of a market has two aspects to it. The first is, in what geographical sphere um, does a business operate? Now, again, this is one of the traditional aspects of market definition, because what we are seeing of late is that the online commerce is really, in some senses, rendered geographical locations uh, irrelevant. But having said that, this is still one of the definitions, which is one of the parts of the definitions of what a market is. The second aspect is, and we will sort of be concentrating on this quite a bit, is the product and the service market. Now, what constitutes part of a product or a service market? And the test under the Act is really, do consumers view two goods or two kinds of goods as interchangeable or substitutable? So is one, if the consumer thinks that one car is as good as another, then they are part of the, they roughly are in, have the same qualities and are the same price roughly, then they would be considered to be substitutable. But to what extent can we really sort of stretch substitutability? I mean, obviously, two works of art can never really be substitutable because they are distinct. And perhaps the argument can be said also of, say, books, for example. Can you say one book is substitutable for another? Now, before I sort of proceed, one of the questions, and I'd really like to bring Harish in, is, what do we think is so special about the online medium to make it qualify as a separate market altogether, as opposed to perhaps just a channel of distribution? What have we learned in our experience? Over to you, Harish.
So I think, Arjun, just in terms of different kinds of products and different kinds of services, there are some things that are only available in the online world, right? Like, let me take the example of, the debate that's going on with the app makers and Google Play, right? Now, apps are not available in the physical world. I mean, they're useless in the physical world, right? So apps are only available online. So as against, buying groceries, right? There you have a choice of buying from your neighborhood store or a physical retail store, whether it's a big chain or a small chain, or online. Now, therefore, I think for different kinds of products and different kinds of services, there has to be a distinction. So while the traditional, marker or test of geography and product or service may not work for the online market only as far as geography is concerned. Again, because geography could be widened and not necessarily, for example, just say the state of Karnataka or or the state of Maharashtra, but all of India could be one market. But I think the relevant distinction may be in terms of the nature of the product or the services that you're talking about. So where products and services are capable of being sold both in the online and offline world without any distinction in terms of the product or the service, then I think it's difficult to call the online market a separate market, but it then will be only a channel of distribution. Otherwise, it could become a separate, distinct market.
I have a follow-up sort of question for you, Harish, and that is really, in related to the past 6 months or so. So, and we have seen, possibly a real sea change in the way consumers behave and their preferences, and perhaps the way they will, do business in the future. And it could be that the pandemic has sort of changed things in a more or less permanent sort of way. So any thoughts on that? While I understand the distinction, how we could draw the distinction between online and offline sort of markets and whether they are just a channel of distribution or not, has something changed over the last 6 months?
I think if anything has changed, I think that change only points to the existence of, or rather the creation of, one single market rather than separate distinctive markets. I think because of the pandemic and because of more and more people resorting to the use of technology to avail of services and goods, rather than going to a store. I mean, then I think the differences to some extent have disappeared. Therefore, even like physical stores are now trying to sell their goods using online methods or telephonic methods, right? So therefore, I think if you ask me, the one clear indicator is that the distinction is sort of evaporating as far as I see.
So I think this is something which is also sort of reflected in the way the Commission over the past 5 years or so has looked at the online markets. And they have really, they started out by saying, precisely this, that online is just one way of selling your goods. So, the offline and the online are interchangeable. So you can't look at online players in isolation. But all of this started to change in, I think, 2017 onwards. They slowly started to recognize that the online market has got some peculiarities and distinct features which maybe make it stand apart. Uh, but of course, it could still be subject to competition from the real world or physical players, as it were. And in 2020, I think we're seeing more and more decisions of the Commission which are treating the online market as a separate and distinct area or sphere. The next sort of interesting discussion that we just wanted to touch upon was this thing about platforms and marketplaces as against products and services, because so much of online commerce today, the conversation is really around what is around the marketplace and what is there in that marketplace. So one of the cases which I think is very interesting for our discussion is actually a case which relates to the stock exchange. And this was a case where the National Stock Exchange was found to be a dominant entity. And in that case, the appellate tribunal held that you can't look at it as a marketplace. You can't look at it as something which is centered around a product, because there the dispute was, could the National Stock Exchange charge a zero transaction fee? And what the appellate tribunal under the Act held was, look, you can't look at it as a product or a service market. It is actually a marketplace, and the service that's being offered is the service of a marketplace. So I think that's something which will be looked at, and maybe an analogy could be drawn with the National Stock Exchange case as far as the big sort of online market players are concerned. But another interesting question, and I'll just bring you into this, Harish, is this thing about how we all get locked in. And this is, of course, this is not the first time. This has been happening for a long time. I mean, we had the whole battle about Netscape Navigator and Internet Explorer, and how anybody who wanted to use Microsoft Windows was sort of driven towards the Internet Explorer option rather than the Navigator option. And then there were these series of regulatory interventions that happened in the United States and in Europe as well. So in a sense, things had to Microsoft had to give a level playing field, as it were, to developers. And I think the app ecosystem that we see today has come out of that. But we still find a lot of this locking in happening.
No, I agree, and I think this is I suppose, there are two ways of looking at it, right? I mean, one, if you look at, for want of a better example, if you take Apple and its ecosystem, right, it's like a locked system in the sense that while you can have any number of apps also on Apple, but compared to that, Google and the Android system is considered to be more, sort of more democratic and open, whereas Apple is a locked system, because Apple is a sort of a end-to-end experience, whereas Google is more of a platform where you can, develop many things. But I think where I would look at it in terms of when you're developing a product, right? Clearly, there are some products that will require, either spare parts in the traditional sort of mechanical world, like take a printer and cartridges, for example, or the example that you gave, Arjun, of the Internet Explorer or Netscape Navigator, Chrome, different tools that can be used on a particular platform. So I think this is a question that regulators have grappled with. This is a question that I think the manufacturers of goods also grapple with as to what is the right way to go, because ultimately they also need to make sure that the customers are happy with whichever choice they make. That is the manufacturer or the industry makes, right? So if Apple is able to have satisfied customers with this, with its sort of end-to-end platform with very limited freedom for others to interfere with it, then it has certain advantages. Um, whereas others may take a different view. But from a regulatory perspective, are you using the dominance in sort of one market, that is in the primary good, to stifle competition in the sort of aftermarket, right? I mean, that's how traditionally people have looked at it. And the example, that came to my mind was, printer and cartridges, right?
Yes.
So should manufacturers of printers design their printers in such a way that any kind of cartridge can be fit into it? I think similarly for a car, I mean, can any part be replaced with anything else? So there's both an argument for and against it, because if you allow any technology to be inserted into any product, then that could cause a lot of other problems. And
Yes.
one of the things that we talked about in the entire Google controversy recently is, if there is no controlled platform, then it could cause a lot of malware, and it could cause a lot of trouble for the ecosystem as well. And even when it comes to say, cars and printers. So I think it's a very difficult choice, and that's why regulators, as you're aware, have looked at it from case to case rather than coming up with a general rule. But the general rule is you can't use the dominance in one market to abuse in sort of an aftermarket. But that's, I think you will be able to shed more light on what our commission as the views
So
are.
I think the car example is one where, I mean, this is something that is an experience, I guess, for all of us who have either owned or driven a car, right? So when you buy a car, you're not just buying the car. So and the car and the manufacturers also realize that you are in a sense, at least for a couple of years, locked in to their system of service delivery to get the car fixed and whatnot. So and of course, what happens in that scenario is, once I do buy a vehicle, I am in a sense the car manufacturer or the auto manufacturer has got total dominance over me. And really, I mean, unless I want to waive my warranty, there's not much I can do. This takes me to another really interesting question. And, Harish, I should point out that, Manoj from Origami had mailed in this question, and I think we've discussed this in the past also, about what happens when, you have a marketplace and that marketplace becomes a market player, right? So this whole thing about private labels. Now, I just share one personal experience of mine. So, and just to show that this is not something which is unique to online markets. There's a grocery store near my house, and the owner of that grocery store has sort of created his own little private label by the name of the store. So he sells, dal, atta, and all those little things. But he's branded, probably branded the plain vanilla product and put his label on it. So it sits there along with all the other well-known brands or the not so well-known brands. So what is really the sort of comparative competition angle here? If you could just give your thoughts on that.
See, this is always a challenge, right? I mean, in the sense that if the shop owner owns the space, right, then how much can you regulate as to how he should stock the goods, right? And whether he should stock his own goods as against branded goods, or if he's trying to push one particular brand or another brand, how should he stock? Is he getting a special arrangement with that particular brand? Um, and if you sort of extrapolate that example to a much larger scale, then if you are a large retailer, then you also have your own goods, so you stock them in preference and stock everybody else's in some corner, right? So I think
Exactly.
and this is this is a question, I think, that will always exist in some form or the other, and this goes to the heart of competition. So there are two points here. One, do you have, when it comes to fair competition, how much can you demand that somebody else should be fair, right? At the cost of his or her own business. And what is the dominance power? I think that is the question, right? You could argue that in every shop, the shop owner is dominant, but that's not the simple test. The simple test, of course, is whether there are other shops around the corner which can stock other goods. So I think we need to look at this in a bit more, sort of at a more, extrapolated method, where you should actually see whether the shop owner is in a position to dictate terms, and who is in a position to dictate terms. And I suppose that the shop example could easily be the example of Google or Apple or Walmart or anyone else, that who has a relative power in that relationship, and what is the impact on consumers. I think all the three questions are relevant, and that will determine the answer in each case. So there's no ready answer for this, as to how do you stock. It's both the question of promoting new business, promoting a choice for customers, and ensuring that there is no unfairness in the competition.
There's there's another aspect to this which we'll discuss shortly, and that's really about knowledge and information and data. We'll just come back to that. But before that, this thing about substitutability, right? I mean, it's one of the core things which is there in the Competition Act, and I mean generally in competition law, jurisprudence, and economics as well, because that's where this comes from. You can have a product which are products, especially in the online sphere. You have a lot of apps, right? And there are in some ways, and they all serve the same function. I mean, I just take the example of one which is sort of quite common to all of us. We all use some messaging app of some form or the other nowadays, whether it's just your plain vanilla SMS or WhatsApp or some other equivalent messenger. But these are all things which are dependent on other people, right? On how many other people can you contact through the service that is being provided. So if you look at the service itself, it's not something which is it may well be substitutable, but the fact remains that somebody has gone there, done it first, right? That creates a particular advantage which the law doesn't seem to as yet recognize in terms fully, as to that is something which should also be taken into consideration. So this thing about first mover advantage, and particularly as far as network industries are concerned, where the network is as important as the product itself. Any thoughts on that, Harish?
See, this is again a difficult choice, and I noticed on the Q&A there is a question in relation to whether the data one is able to gather through the network and through the first mover advantage and through the users, does that give an unfair advantage as well to the person who is acting as a gateway to that network or data? And I think, see, it goes back to Arjun, what you mentioned, first mover advantage, and the relationship or the market or the business that you have created, correct? And whether that business and network that you have created, and we should not forget, like all the, for example, I know in the US, all the three large data companies, all the three large tech companies are facing a lot of heat from the US regulators on, like Facebook, Google, Amazon, all of them. We shouldn't forget that, it was only like, what, 2-3 decades ago that all these three companies were um, at the forefront of innovation, right? And they were all small and they have grown to be this large. So, well, they've created new forms of networks and new forms of uh, customer retention and delivery and service. The fact that they also gather data, um, does that then, so there are two questions. Does that entitle somebody else who wants to start a business to say that I want access to that network or data? I think that's a question that, I think we have to answer. It goes to the heart of competition law, I understand, from if you take the traditional shop owners perspective. But when you're talking about, an online space where you may not be able to, um, you know, uh, see the goods in just like in an offline space or services in an offline space, I think there may be need for coming up with a slight tweak as to how you regulate this relationship of network and data as such.
I think that's really the next sort of big issue that we wanted to discuss. Harish, and your comments have taken us straight there. That what this thing about data and where we stand with data, and it's one of those crucial things which is likely to be a determinant in the way in the future, and a major way, a major aspect of the market. So one of the things which I think the our traditional understanding of what constitutes dominance doesn't really sort of take into account is this power of information, right? When we talk about resources or that a company or a market player may have, uh, it doesn't explicitly recognize that the data could be as important a resource as perhaps the money in their pocket, right? Maybe not as important, but definitely up there in the scheme of things. And then having acquired this data free of cost, I mean, because love free, right? I mean, there's no dispute about that. So we will happily pay 3 rupees for our newspaper because we have been doing it for so many years. But when it comes to paying for online news, I mean, we all wonder, is it really worth it? And I think we're all suffering the consequences also of that. But having said that, you know, nothing is free, right? There's no such thing as a free lunch. Quite often you're asked to register when you want access to some content, and you are giving out your personal details at some level. So there is of course this issue of privacy, but as far as the competition law is concerned, there is the issue of data, right? So any thoughts on this and how we can sort of factor this into our analysis of how firms should behave?
See, I think so. There are two things, right? I think there are two issues here, Arjun, as I see it, and one issue is not in the area of competition law. Okay, that is the data gathering and the relationship between the initial data gatherer and the person who is the subject matter of that data. Okay, so I am using online. I'm checking out online news, and because I want it for free, I have given my consent or whatever. So that's the relationship between me and the person who's providing that service, right? So by clicking uh, yes blindly to many things, I have essentially agreed contractually to for that person to use my data in various forms. Now, I think that relationship is an unequal one to a large extent because it's like a standard form contractual relationship. And that is not really in the area of competition law as we currently stand. So that needs to be regulated separately. So let's leave that out as to what is fair or unfair in that, right? And if you want convenience and if you are willing to, suffer some price for that, then that's a choice that you need to make. And there are more issues there, right? I mean, because it's not just a question of choice all the time. I mean, it could also be other things. So let's leave that, the regulation of that relationship and what is fair, not fair in that relationship for a separate discussion. But once the data is gathered, then do others who are in similar businesses or who want to do some similar businesses or who want to use that data, do they have a right to that data? I think that is a question. And I think, the answer has to be in some form, no. I mean, you can't just claim data that somebody else has put time and effort in gathering. And one of the, things, unless of course it's regulated in the first instance, in the gathering itself. But once you have allowed people to gather this data, and if it is really so valuable, because I think a lot is still to come in the issue of this data, I think, because, and it is not as simple as, okay, they know something about, Harish Narasappa or Arjun Krishnan. It's not, it doesn't come down to that level, right? A lot of the the data becomes useful only if it is, if it is along with many other data points and can be analyzed in real time and all of that. And the identity of, you or me may not be, that relevant. Although, it is scary when you're searching for something and then there's an ad that pops up next to, your email saying, do you want to look at it? So that shows the power of data, right? But I think there is something, something, at least in terms of as a law that has developed until now, I think that there doesn't seem to be a basis that entitles a newcomer who wants to start a new business or an existing player who wants to get into this business to demand that somebody else should share the data that he has collected from his customers or whatever, right? And I think that's where, competition law comes in. I mean, but if you are collecting data because of others' usage, like, if you look at Google and, or Apple or any other platform, and they are managing to collect the information of not only people who visit the Google sites, but also the different apps that are coming there, that are being used there, then how should data be shared between the app owner and Google or somebody else? I think those are all interesting questions. And if you are using that data on usage of other apps to then promote your own apps, I think there are clearly questions of competition law there.
Sure. And, while we were on this discussion about free stuff, there's this whole controversy, Harish, about what's happening, or, Paytm and the Play Store. So I think everybody wants to know a little bit more about it. And, what is our analysis on this? What is our take on this?
See, I think really what is causing a lot of angst is the fact that now Google wants to charge this 30% fee or commission on the purchases that are being made within apps, right? And asking them to use Google's facility. And this is really at a 30,000 feet level. I mean, there are a lot more nuances to this debate, and whether that is an unfair requirement is an issue. And again, if we take at a basic level, if we take the example of a mall, right? If you go to a mall and the mall owner not only tells the stores, not only charges rent from the stores, but also tells each of the stores that I need a commission on whatever percentage of sales that is happening. And on top of that says, but how the customer pays you is also to be determined by me, because they have to use my billing system. Okay. And also says, I will also determine where your shop should be located irrespective of the rent you pay me. Okay. And if I feel that I will also sell some of the goods that you're selling, I will put those stores in the mall up front. So this is a kind of, sort of rough comparison that you can make. But at the same time, if you look at what has happened on the Play Store, is that so many restrictions were not there. Like the restrictions that I talked about in the relationship between the mall owner and the different stores, these restrictions didn't exist on Google Play Store. So many of the apps had a bit of a free ride, right? And they've developed their own businesses. So it comes to your question of nothing is free, or to your statement, nothing is free. Plus, how long does the convenience work? And it could be Google's argument that, listen, many of these things have happened because of the infrastructure that I've provided in the first place, right? It's not as if there was a market for these apps before I allowed all these apps to be developed in the first place. So I think these are the questions that need looking into. And I think it's an interesting case. I mean, if the commission does take this up, I think there are a lot of questions that we can drill down to and analyze. So it'll be very interesting to argue this case if at all it goes to court. Yeah.
Sure, absolutely. So I think we are nearing the end of our discussion, and I think we have 40 minutes are up. But just before we close it and then start taking the questions, only one thing which, I mean, a recent development which I would like to point out is, usually one looks at dominance has to be established first, and then you look at abuses. But there's a recent judgment of the Supreme Court in the Uber case where they decided that an investigation could be launched without really first establishing dominance, but actually looking at the level of discounts or the loss making that was happening. And if a business could sustain loss making for some time, then perhaps it was actually an indication that it was already dominant. So that's something that's to be kept in mind. So there could be a change in approach on that basis. I think we'll now move to the questions because I think 40 minutes are up, Harish. Should we just start taking a few questions?
Yeah. So there are four questions I see. I think we can take the one on natural justice at the last, because that's not really that significant. Whether there is a need for an overhaul of the Competition Act for the online markets, for example, a shift towards alternate merger control thresholds such as deal value merger thresholds. Arjun, to answer that?
So I think the answer there is that, look, I think it's a little early for that to happen, but I think what should really happen is a deeper analysis of what a company actually possesses, which is sort of lost in the figures because we have a threshold-based analysis which doesn't necessarily capture the potential of the influence that a company actually wields. Because, as you know, I may have a stake in a company, and the company may not have much by way of assets because it's that way. In terms of the software or the intellectual property or the app that it has, disrupt technology. So in some senses, I think merger control, the way it is structured presently, can't really adapt to the speed at which things are happening in the online market. So that is something to be considered. Okay. Any thoughts, Harish, on that?
No, I agree with you. I think I don't think there's need for a separate law on online markets, and I think the way our Competition Act is structured, I think it gives a lot of room for the commission to look into these issues, because the act, as you pointed out in the initial part of this presentation, Arjun, is very generic, right? I mean, and it gives, the definitions are quite wide, and it gives there's a lot of room for interpretation and liberty for the commission to explore some of these topics. So I don't think we can just think that let's write a new law. I don't think that's the point. I think the commission needs to become a bit more clued in terms of these online practices, and that's a difficult thing to ask because lawyers in general are finding it very difficult to keep in touch with the technology.
No, absolutely.
Technologies move.
So one thing that perhaps that the commission could do is actually make it simpler, for merger filings to happen. So part of the hesitation, which, I mean, we have both done this, Harish, in terms of advising clients on competition regulation and whether they should approach the commission for a merger filing. And one of the biggest hesitation is the prolixity of that form and the amount of data and information that you have to divulge initially, right? So I think that's the major hurdle, and that's one of the reasons why everybody wants to somehow avoid it. So if the filing itself could be simpler, and you then possibly get more people to come forward and give the commission a real opportunity to look at the business as a whole rather than simply doing it as on an arithmetical basis.
Yeah, Arjun, there's another question on the chat. Can exploitative privacy terms by, let's say, FB or Google be considered an abuse of dominant position to the extent that they could not have had those terms if there was competition in the market?
So, this is, again, taking the offline example. You had a case against a major real estate developer, right? And that too in the market for luxury apartments. And the kinds of terms that you saw there have now actually become commonplace in many real estate contracts, right? The fact that there's unequal bargaining power, it gives the real estate developer the right to add units or apartments or change the construction, change the number of or amount of services that can be provided. So yes, of course, there can be potentially an allegation that could be made in terms of what you have to divulge in order to get access to something which is which many may consider now basic, and really Supreme Court has also sort of recognized internet as part of the right,
fundamental right.
Yes. So again, a lot depends on the facts of the case, but it's definitely something to explore there.
See, and I think the only point that I want to add, Arjun, is if you just in the example of the apartment purchase of apartment, I don't know whether so many people would be using Facebook if it was not free.
Yeah.
Right. And so if it was not free, would they be able to still impose all these various other conditions? But the other argument to that, the counter to that is that, their model is not based on making it a paid service, right? I mean, the whole point is they want more and more people to come and use their platform. And that's the power of that platform. So I think, there is some, a sort of basis to ask whether the privacy conditions should need to be more fair. But I think that's where I think in that relationship between the business person, the business house, and the end consumer, that relationship on its own needs to be regulated outside competition law as such, right? Because what courts and governments seem to have taken, and even if you look at the privacy law across the world, I think that seems to be considered as part of contract law and consent and things like that. So whether there needs to be regulation of that in terms of as similar to standard form contracts, I think that is something that as lawyers we need to think about. But whether that is really an area for competition law, I doubt very much in that relationship.
So I think, again, competition lawyers, like all specialist lawyers, tend to think that their area of law is sort of a panacea
for
all
areas, but
that is not the case. That is not the case. So I think we have another question. Again, going back to this issue of private labels, I think responding to our discussion, isn't the issue different when it comes to online marketplaces who sell private labels? Because of the access they have to third-party data, isn't that an unfair trade practice? Could you answer in light of the Amazon case? So I think firstly, the Amazon case was not, the one that's at least currently in the High Court that you and I are involved in doesn't have to do with private labels.
No.
There was a recent order of the Commission closing an investigation or not ordering an investigation, in which there was this issue of private labels raised, but it was closed for different reasons. But yes, I mean, the concern as far as private labels is because of the unequal sort of position that the marketplace enjoys because of the access to consumer data. So they know what the consumer preferences are. They know what is selling, right? So that is another aspect, that the advantage that the marketplace has. And the peculiar advantage that the online marketplace has is that, when you do search in for a result, and this is true as much for a search that you conduct on Google or any other sort of web search engine, is that you rarely go beyond the second or the third page when you look at your what you want to buy. So if you are able to find immediately something which sounds reasonable, seems to be what you want, and perhaps at the right price point, then you are tempted to buy it. And I mean, that is really the crux of it in terms of consumer behavior. Whether that's a competition issue, and that is a larger question. But yes, there is a competition angle to it, for sure.
Arjun, there's one more question, which is, there are two more questions, but let's take this one first. Can data be considered an essential facility? My own view is, what data is the first question, right? And to whom is the second question. It is not, see, this is where I have a problem. Nobody has a right to data to start their business. I think that is where the misconception comes, right? And that is not just in terms of data that is actually collected already, but even the right to say that, listen, if you do business with me, I will collect all data about you and then I will do whatever I want with it. Apart from the primary business relationship that you and I have, right? So if I am a customer buying groceries or medicines from an online store, it is no different from me buying medicines from a pharmacy. Now, does the pharmaceutical guy also need to know that I have a disease, or how many people in my house have that disease, so that they can sell the medicines to me all as regularly as I want or I don't want? I think these are the questions. So what is the data or information required for the primary relationship, and why do you need to collect information beyond that primary relationship? And then do you have a right to use all the data that is not relevant for that primary business relationship for something else? I think that is the first question. So, and in my personal view, I think the answer should be no. You can't just collect whatever you want. You seek information that is relevant for your relationship. And then the second question that is now being agitated is by other businesses saying, hang on, if he has access to all the data, why can't we also get access to the data so we can develop our business as well? I think both are, in my view, in my personal view, questions that need to be examined further, because there are a lot more significant issues involved rather than just the right to conduct business. And I was saying this somewhere else, I don't think we have a right to conduct business at somebody else on the basis of somebody else's data. So I will stop there, but I would love to hear your views on that.
No, I think this essential facilities thing is, something which comes from intellectual property law, that, I must have this essential patent or essential license. Otherwise, I can't do my business. So then there are, certain add-on questions. Am I entitled to get the data for free?
Yeah.
Because in a sense, the first mover got it for free. He didn't have to pay anything. He just had a great product. But he got it for free. Now, the next question is, okay, I will say I'm willing to pay for the data. And then the next response would be, okay, how much? So how much? First is whether this data can at all be given, like you said. But if it can, then for how much? And are we going to have the next really sort of great battle over pricing on the price of data? So that's another interesting question. I think there was one more question on natural justice, which we promised to take.
I think maybe you should.
So I think yes, the short answer is yes, the Act does provide for it, but it doesn't provide for it at all stages. And that is, of course, one of the reasons why there's so much litigation around investigation. So at the initial or the threshold stage, there's only a limited, when an investigation is launched, there's only a limited right of hearing. But later on, there's a full right of hearing, there's a full right of appeal, there's an appeal that goes all the way to the Supreme Court on all issues. So I think the answer is, of course, yes, natural justice is a part of the act, just limited to begin with. And the justification perhaps is that, look, when someone is launching an investigation, then they should be given a certain amount of free play in the joints to at least go out there and investigate. Possibly, as the analogy would be the police analogy. If the police sees that something wrong is happening, they can go and have a look at it. And at least they don't have to ask questions, give you a hearing before they start investigating.
Okay, that sort of brings us to the end of this discussion. I think there are many questions, I think, that arose, Arjun, which probably require deeper analysis, maybe another, discussion session. But thank you all for participating today, and and for the questions that were very interesting. Thanks a lot, Arjun. Thanks a lot, Shivani and Ria, our colleagues who have helped us in putting this session together. Thank you very much.
Thank you, everybody.